Okay, if you could make sure that you get that.
Again, my name is DJ Pendleton, the Executive Director of the Manufactured Housing Association. I appreciate the opportunity to come before you guys today. I think maybe a good starting place is to kind of go back and refresh a little bit of the background. You're probably asking yourself, why is the manufactured housing guy sitting here talking about modular homes? Well, it's because we also represent all the modular builders, most of the modular builders. Matter of fact, I've got a lot of them that are representing various different modular builders sitting behind me today, probably at least 80%. Several of them are my board members, so I'm sitting up straight and going to do well today, I hope. So I want to thank for the opportunity. I want to thank first for the hard work that the department put into responding to these. I want to state that I apologize for the length of the questions. And even maybe even some of the wording or tone, I've been accused at a time or two that so probably an occupational hazard. They come across as a little leading and sometimes interrogatory based, and I don't want that to be the perception. These were compiled over quite a series of time with several meetings within our association as to specific instances that were happening day to day. I've got some folks here that can obviously speak more articulately on some of those and some of those experiences to provide any kind of background, especially if you find yourself looking at maybe some of our original proposed questions and say, where did this even come from? We can go into that. We've got some resources here available for you. If I can just maybe start, and then I'm not exactly sure, Mr. Chairman, how you'd like to proceed. I mean, we can bring up some other people on a panel or whatever's most efficient. But
well, let me say, DJ, I think in the interest of time, we would prefer not to go through. I think you have 32 items.
Right.
And so I think we would prefer not to go through each and every one of these and have a back and forth between the your group and staff. Are there some glaring, you've had time, let me ask you this, you've had time to review staff's responses. Are there a handful that you disagree with? Are you generally in agreement with these responses? Did these clarify some things for you, or
sure.
Can you speak to that?
Absolutely, all the above. And some of these questions I'm going to be asking is for kind of some further clarification. Let me start first on one of the bigger topics, which was the one about the I don't want to misstate something as far as warranty. We're not going to go down that road. But basically, we're looking for a definitive timeline of potential liability. At what point does the clock start and stop as to when a valid consumer complaint can come? And this was discussed a little bit at the last meeting, and they articulated in the responses. But I'd like to put as fine a point on that as possible, in the sense that if the response and the process that the department has is that 2 years from what the rules say is the event giving rise to the event, or giving rise to the event, they've got a 2-year window, and anything beyond that has to show good cause to the executive director. Okay. Now, if we can, I would like some further clarification on what is the event giving rise. And what I specifically mean is that, well, I think one of the things that we proposed is that once a home is installed and signed off by the third-party inspector, that's the moment the clock starts running. Therefore, anything beyond 2 years from that moment is something that has to go under that higher level of scrutiny. And in addition to that, there's no definition of what good cause is, or at least none that I could find in statute, applicable 1202 occupations code, or within the administrative code, which is fine. It's probably one of those, you know it when you see it. But I didn't know what the process was as far as if that higher level of scrutiny, if the executive director signs off and says, yes, this is good cause, and signs off, if there's a writing documentation, if there's justification as to what did amount to the good cause in that judgment, and if not, if that could be provided.
Well, let me ask you this.
Sure.
Is there instances where you know of complainants showing good cause and the executive director has opened a complaint?
I don't know to that question. The reason we're bringing this up is because it's been brought to my...
No, I understand.
Okay.
It's really a two-point...
Mr. Chairman, can I answer that?
Yes.
I have never had one.
Very good. Very
Okay.
good. Okay. So let's...
It's all hypothetical at this point.
Okay. So if you don't mind, DJ,
Sure.
let's lay that issue aside and address your 2 year from...
Sure. Sure.
from issuance.
Okay, and maybe to pull out of the hypothetical is that there's actually pending cases that if you check from when they were installed to when the complaint was filed, it's
Well,
beyond
but
2 years.
that's a different issue.
Okay.
You're talking about they specifically opened up after 2 years, giving rise to the 2 years of the event. And I
Sure.
think what the discrepancy here is, what is the event? You
Correct.
as the industry want the event to be, when you're done, you got paid, you signed off, and we're out of here. But the department is saying, well, if somebody calls and says, my roof fell in, and it fell in last week, well, last week is within the 2 years, and they've got to go out and take a look at it.
Sure. Now,
Even
and that's,
if you
and-
did it 8 years ago. If your guys did the work 8 years ago, the roof fell in last week,
Right.
the department still has to go out there because of their interpretation of the 2 years was last week. The event was the roof falling. not
Okay,
the-
right, exactly. You're right. That's what we're trying to provide clarity on, is what the council's opinion is as to what the triggering mechanism is for the
Okay.
timeline. So that I can go back and tell my folks, this is what the rules are.
Okay.
Mr. Chairman, can I
Yeah,
ask,
go ahead, Joe.
can I ask for a little clarification? Are we talking about warranty here? Are we talking about the TDLR rules? I mean, give me some background here so I can understand what we're talking about.
I can try. I've got some other folks that might be able to provide some additional background. But what we're talking about is when a consumer complaint comes in and TDLR investigates that and goes out and based off of code violations issue citations based off code violations to a builder or manufacturer, excuse me. And so that's what we're talking about. There is no warranty. We discussed this a lot last time. That's one of the issues. It's not in statute. There is no statutory required warranty. And so that's exactly what we're trying to. But on the industry side, it works very similar to a kind of a warranty issue.
But you do have the statute of repose, which is a 10-year liability carried forward that's in statute. So there really is a 10-year statute of repose.
For civil litigation, yes.
Right.
Right. So and that's a good, if that's what we're trying to find clarity on, is that if the council believes that the stopgap, if you will, for the industry is 10 years, then that's what we'd like to know and provide the clarity because of the comments that were made last time about the 2-year justification.
Yes, go ahead.
I mean, can we get some help from legal? I'm still curious if we're talking hypothetical or if in fact this is not a discussion that should be held through council at appropriate times. In other words, after a complaint has been filed and then the two parties come together through some sort of agreed order and say, guys, this has been 12 years since we sold and installed a home. Why are we here? We've got a 10-year liability limit. Is this something this council should be taking up?
Well, Adela Lindquist, Assistant General Counsel, it's not really a warranty issue. It's a statute of limitations really for a time frame to file a complaint. It doesn't dictate how long it takes to resolve it. Sometimes it might take longer than that, as we all know, with the way things can get piled up. So basically it's a rule. It's an administrative rule in Chapter 60 for this agency regarding all programs that says the complaint must be brought within 2 years of the event giving rise to the violation. That's not defined in there, but that's the way it's written, or otherwise if there's good cause given. So this has nothing to do with warranty or liability or how long this could follow you around. It just is how long it is required for someone to file the complaint.
Right.
And Councilmember, you're absolutely right. What we're dealing with are pending complaints, and a number out of the 32 questions, I would venture to say several of them relate to complaints that are ongoing right now.
Okay.
Even one of the questions raises a concern about us opening a complaint during litigation, but has us lay out and requires us or asks us to lay out defenses and processes for them while the complaints are pending with us. It was troubling to go through the document. The process is open for them to sit down and meet with our legal folks, work the issues out, contest them, agree to them, whatever the case may be. That due process is available. Our answers, we committed to giving you an answer to every question, and we did. We didn't give you specifics because they are general scenarios. They're very general scenarios, and DJ is absolutely right that the word good cause is not defined for any state agency. Good cause is out there because you know it when you see it or you don't know it when you see it. We can continue to go down this path and talk about the things. I would encourage the council, to the extent that it's possible, to make sure that we're talking about it in general terms and not the specific cases, because we have cases that are pending that the impetus is clear. It's clear to us.
Chairman, it seems to me, that we're talking about two distinct issues here. One, the, TDLR doesn't specify, it talks about warranty, and I don't think they should. That's between the purchaser and the manufacturer. So you could have a warranty that says 1 year and clarify what that means. So that's a point of law. It would be handled in a civil court. Then you're talking about another issue here. If somebody files a complaint, then the TDLR has a responsibility to go out and investigate. And if that complaint has merit, there is a statute of repose of 10 years. And that's been around in Texas, as far as I know, for a long time.
Sure.
And so then we're getting into a civil issue then. If it's more than 10 years and they file a complaint and somebody comes back, then the statute of repose says you can't, there is no civil, court of action that can be taken here after 10 years. So aren't we sort of talking about, we're getting into an area that is really already governed by the civil statutes and shouldn't be a part of I think what you were trying to say is, should not be a part of the council.
So by that logic, you're tying the time frame for consumer complaint violations to come into TDLR to the statute of repose, meaning anything within 10 years?
I'm saying that those are independent.
Okay.
Somebody can file a complaint within 2 years of something happening, and if it's, 10 years and 1 month later, and they file the complaint, TDLR goes out, investigates, comes back and says, yeah, there's something wrong here, then the complainant really has to, there's nothing that TDLR should be doing. They're just saying, they're verifying that the complaint has merit.
Sure.
And then the complainant can then go get a lawyer, and the lawyer's gonna tell them, hey, it's been 10 years since this thing was, put in place, and so there is no complaint. Or it's been 8 years, and then you can go to a civil court and deal with it that way. And then, you guys handle it or try to settle it. I'm not sure how this board or the Texas Department of Licensing could come up with something that would not be in conflict with state law.
Understood, and we definitely don't want to do that.
So when I read this, that's what I was going like, what are the issues here?
Well, I guess, and maybe Martin could talk
DJ,
about
let
your
me
perspective.
interrupt.
Sure,
I
go ahead.
apologize, but I sympathize with this issue. I'm a single-family home builder by trade, and my family's built over 10,000 homes in El Paso, Texas. And from time to time, we have a house that was built 22 years ago that someone says the rock wall's falling down, it wasn't built right.
Right.
Now, that's my issue between me and my customer, but sometimes they call the city of El Paso and they ask someone to come out and inspect it. Now, the city of El Paso, they can't really tell them no. I just think you have to look at it from the TDLR standpoint. They have to go out as in response to the public, and they have to go out and at least look at it. And in your case, let's say, for example, a roof fell in. 12 years later, I think TDLR still has to send someone out and say, yeah, and even maybe make a determination that this violated the code at the time. Now, what the customer does with that and what TDLR does with that, it sounds like we had 9 findings last year, and the maximum fine issued by the agency was, I think, $2,500. Now, there was a default order and one that went through all the way for, I think, $6,500 and for the default and $8,500 for the, SOA hearing.
Sure.
But, we're not talking about, hundreds of thousands of dollars, and if the statute of repose is in place, then the customer doesn't have any any recourse against your guys if it happened 12 years ago, because there's civil court is not going to hear the issue because the 10-year statute of repose has passed. So I'm kind of just echoing what Rolando and Joe are saying. I don't know how we can really address this. We can't ask TDLR not to respond to a complaint when somebody calls. Now, the complaint may or may not have merit, but it seems to me you're asking, it's been 2 years since we had a relationship with this customer, so don't call us. And I don't think we can. I mean, I would love that rule, but I can't expect that either.
Well, in your example about your rock wall, so when the city of El Paso came out, did they then issue you a violation for not complying or not maintaining the under the IRC that you built at that time? That walk wall didn't basically satisfy the IRC in perpetuity of the existence of the structure?
I think it gets into who's the inspector. Is he reasonable? There's just things you go out there and you work through it. If I had ignored them, if I had said, you know what, don't call me, that was my grandfather that did that, leave me alone, and hung up on them, I'm willing to guess they probably would have done everything you said. But if I said, you know what, let me go with you and see what the deal is, and then when we walk out there and we say, 22 years for this rock wall is pretty good.
Sure.
And the inspector's going to go, yeah, Mrs. Jones, 22 years for this rock wall is pretty good. So if that's not happening, I think that should be addressed on an issue-by-issue basis.
Yes.
Are you having problems with the due process? Are you finding the due process to be skewed? Is that what you're trying to?
Can I bring some other folks up here that are actually dealing with some of these issues? Is that appropriate, or do you want me to continue? I mean, I can try to answer it since you asked me directly, but I guess I have people that do have firsthand experience.
Okay, let me interrupt you again, DJ. And I know you're representing a large group of people. One gentleman here raised his hand and nodded his head yes, and to answer Rolando's question. So I think though what this body would like to see is on a case-by-case basis bring those before us. We can't address a general rule that I don't even know how we would address anyways.
Sure.
For some specific instances where maybe an inspector was overly aggressive or
sure. So
not
that if you
reasonable.
prefer, we can start to bring up in case-by-case basis. That's absolutely fine. If that's
and then you've got the complaint process now.
Sure.
And so I think maybe council can help me with that too. I mean, isn't that usually handled between a builder manufacturer and someone from our body, enforcement?
Sure.
And then I don't even know if this is the place to appeal.
I'll tell you what, Donna, if you could help, maybe a year or two ago, there was a specific manufacturer who had come at odds with the rules of the program. I think it was something to do with the design of concrete walls.
That's right. Yep.
And
It was an out-of-state.
It was an out-of-state, and that manufacturer elected to come in front of this council, present their case, and ask for an opinion or directive to staff to move forward with that. Didn't that happen?
Yep.
Yes.
That was not a complaint case. That was a case where the manufacturer was going through certification. They didn't complete the certification process,
Before they should.
and they shipped the buildings.
Okay.
That was never a complaint case. A complaint case would not come, an open complaint would not come before this council.
It would go before the SOA
It would go through,
ultimately at the end of the due
If-
process.
The agency would pursue the case, issue
Right.
a notice of alleged violation, engage in discussions with the respondent to see if they wanted to enter into an agreed order. If they did not want to enter into an agreed order, their due process is to go to a SOA hearing. And then the SOA hearing issues a proposal for decision, which our commission would then review and make a final decision on.
And so, sort of an open question both to staff and to council and to the commission. Does this body even have the authority to preemptively listen to a topic to even give staff the directive to move forward with a complaint notice or not,
No.
then, I mean, that's about the only thing I can see is, okay, if staff is about to initiate a complaint procedure, that it could potentially come before this council for us to assist in resolving that, but I can't imagine that we have that authority.
Because they have a whole process spelled out.
Yeah.
What about
Yeah.
on staff issues, Mr. Kuntz? If there's a Inspector A who's got it in for manufacturer B and I'd like to address this body and tell my story, what about that?
Well, an individual could file with the executive office, and we can examine that and take the appropriate action to remedy the situation by reprimand of the person if they're bad, or reassign the person or whatever. But it may be that the individual's not bad, it's just that there's a conflict of personalities
Sure.
in the way they interact with each other.
But the point is, there is a recognized process
Right.
for resolving those issues that has really nothing to do with the council.
That's correct.
What if they're dissatisfied with your action, Mr. Kuntz?
They'll go beat up his boss, the commission
The
level.
commission's there for that.
Yeah.
Your position is policy. Mine is administration. So, and what we're talking about is administration of the enforcement, the regulation of the act.
This is Doug
My
Robbins.
nature is to try to build consensus and all that stuff. I'm a little tired this week, so my nature's not as high as it normally is. But I will try to offer this to the council and to DJ and his folks. The time to respond and resolve to a pending complaint is not here. This is the inappropriate forum for that. However, as complaints are resolved, meaning those that you have been resolved that Trevor talked about, and there are elements in there that resulted in interpretation that staff had. We had a finding that said section 70.101H is why. It's appropriate for the council to go back and say, oh, well, we really think there needs to be better clarification on that element. But it's not appropriate when cases are open, they are fresh, the opportunity to sit down with Trevor and the folks, maybe not the opportunity to sit down with the people that you want to sit down with, but the people that we have made available to you. The people who sit down that are in the process, it's still there. It is still viable. Those complaints are right here on this list. That means they're not closed. It means they're not in hearing. That means that they can still talk to the enforcement division, and the enforcement can gather information, and they can say, I don't know what that code means, but they can go and elicit the information from our staff and get some better understanding, or they can question our staff and say, are you serious? Are we really doing this? But that opportunity is available now.
Okay.
But to have it aired out here individually is not the place. It's not how we do business.
Okay.
This is Doug Robinson. And while there have been questions by a regulated group, and we have responses, and further, there have been suggested changes proposed, just in text. And it seems as though we're touching on state law, TDLR rules, industrialized building rules. As we've been talking through the one of 20 items, I think a number of these things warrant discussion. I don't know if a task force is, I don't know if staff is the appropriate avenue, or if a task force is the appropriate avenue to see where we can go. A task force could go through these over time and potentially bring action back to this council that could be moved upon as an agenda item, rather than just us going through conversation on separate items. But I'm not sure what the avenue is. I think it does warrant more conversation. I don't know, certainly deeper conversation than just the questions and responses. But I don't know if that's back and forth between staff, or if it could be a task force of board members, industry. And having just gone through the code adoption and changes there, where we'd get on the phone and discuss those weekly, bi-weekly, I think it's something that we could do methodically over time.
If I could just add on to that, because I guess I'm sitting here kind of trying to struggle to find what you're talking about, to maybe try to address some of these things in policy, or if they're not, if there's limitations, if these things have to be changed statutorily, or it's just an education piece to my members to tell them, them's the rules, you know, because there's a little bit of confusion there. I guess, you know, in the last 10 minutes, Mr. Chairman, you were saying, well, we could bring specific case files before, and then the other, we said we don't want to talk about in hypotheticals, and then I just heard, okay, we can't bring specific case files forward. So I guess I'm a little bit at loss as to what the process would be.
PJ, you can't bring case files here. You're not gonna have, we're not gonna be able to allow you guys to have your witnesses testify about pending cases. We can't do that.
But
he did say-
That's what we got the enforcement process for.
So can we talk in hypothetical then, on fact patterns
But Mr. Chairman,
or procedure, yeah?
And-
I have further, I think this is true procedurally, that while there is a question and answer here, and there are some suggestions, the board isn't being called to take action on anything specifically. If we were going to do that, it would need to be on the agenda, it would need to be considered with information more than just conversation today. Is that accurate? All we have are the questions, suggestions, and responses.
Sure. All we have to.
So, next step, is it staff, is it task force? What's next step?
if
Well,
I may.
nope. I'm sorry.
And if I may, I don't mean to cherry pick one out of the 30-something points here, or the 20 points here, but, Mr. Chairman, what exactly are we to do with, say, 18? Does the department allow subjective opinions to be the basis for violations?
They answered the question.
It's answered? I don't know, what would this body even try to do with a statement or a question like that?
What if it's not being followed?
And then you file a complaint through the due process. Excuse me.
I don't think that's a spot for us to decide, though. If you, through the chair, I'm sorry, this is Randy Childers. I think if you think there's an issue procedurally, I think it goes through staff first. I mean, I don't know that that's the kind of thing that comes before this group.
Well, I mean, this is Della Lindquist. I'll comment just a little bit. That goes to credibility of witnesses and evidence, and
Right.
so they wouldn't really
So,
hear any of that. That would be if there was a fact finder to determine the credibility of a witness. There's subjective comments made all the time. Expert witnesses, people who believe a violation has occurred and this has hurt me or this has happened to me. And then someone's going to come back and say, no, it didn't because A, B, C. And so a lot of it comes down to weighing, evidence. And so that's not really what we do here. That's what the SOA judge might do, or maybe in an agreed order type situation or mediation. But
Sure, and I don't mean to confuse this, let me just kind of talking about that in the SOA. If opinions are put into a violation report that are based, let's say, either on subjective opinions or they're based off of a conversation that is recorded in the violation that the inspector had with the consumer or the complainant, that normally that conversation is hearsay. So the only way that person can make that assertion in court or in any kind of SOA or anything else is to actually come. The problem is that once that is put into a violation report, it is now an exception to the hearsay rule and comes in under the public records because a violation report. And it's viewed by SOA judges and arbitration judges as de facto expert witness testimony, which are based off fact questions. And many times the trustworthiness of the assertions and the opinions could be otherwise called into question. If nothing else, not personalities aside, credentials, credentialing expert witnesses, whether you've got a professional engineer that's certifying this or something else.
Let's assume that we don't disagree with your statement.
Sure.
That's not the purview of this council. Somehow,
Sure.
there has to be a methodology for you to address the concern of that due process.
It's called cross-examination.
I would assume so.
It's called cross-examation. If
But
a
not
person
here.
believes that information was included into an inspection report, and trust me, they're not held sacrosanct. We have a lot of questions from our SOA judges against us. But if they believe that the information was included in an inspection report as hearsay, then that person would have the opportunity to cross-examine the witness on that information or to bring a counter witness to show that it was hearsay. It's called cross-examination.
But that's not the purpose of this council.
Absolutely not.
I mean,
And
if you.
Mr. Chairman?
Yes,
if I
go ahead.
Can expand on your opening, when you were talking about the scope of this. We have 11 cases that are currently opened in the Enforcement Division.
Okay.
7 of those cases were opened in 2010.
Okay.
4 of them were in 2011. If you look at the number of units constructed in 2010, that's 2,608 units. We're talking about such a de minimis number. It's amazing to me that we're in this forum spending this much time on that.
And I don't mean to
With
waste the
one-
time, but we're just talking about residential. I'm not talking about any kind of commercial.
And-
So
and
that number goes down to about 500, 400 total units.
And I will tell you this, the one, Mr. Chairman, Rhonda again, the one caution that I would offer you, Mr. Combs and staff, is as a professional engineer and as an individual who has a private business, it may be a tiny fraction of what happens in the industry. But when it happens to that one individual, it
big
is
deal.
all-consuming. And you do feel like one individual up against the state of Texas. And boy, that is a horrible feeling. And so, to that end, please just acknowledge that.
Absolutely.
Oh, yes.
You're
We
right.
do.
You're right.
Care for the individual on both sides.
You're right.
But anyway, but I still don't see how this is the venue for this discussion.
Mr. Chairman, may I ask a question of council here? And to me, if, for us to be able to deal with anything, you have to come forward with a recommended change in the rules or clarification, specifically, as opposed to bringing a list of complaints. I mean, that's my understanding of why we're here.
Yes, yes, sir.
And so if you all want to have anything done, you need to come through this thing and say, if there's some rules that you feel like that need to be clarified, that is something I believe the council has the ability to deal with. But just listening to complaints and you know, getting into who said who and how that's getting into civil law, that's beyond the scope of this council, is my understanding. Is that
Yes,
correct?
and I will say
Reasonably?
one thing, you know, if you're talking about the hearing process and fair and evidence that's weighed and hearsay and that whole thing, you know, I've been to a lot of SOA hearings, and a lot of respondents, you know, don't have an attorney, and I see the judges bend over backwards to accommodate that. And as far as hearsay goes, I'm not saying hearsay doesn't get through. It's not our responsibility to object to that. But if, you know, I've seen more judges than not allow it in. I've seen that. I don't know what experience you might be quoting from or whatever, but I've seen many, many judges not allow it in by their own motion. So, again, everybody has the right to counsel in the case. Everybody has the right to bring their best defense and mediate with us or talk with us. So I'm certainly not the director of enforcement, but I don't know what your issue is with
But
the hearsay and all that.
specifically for our
No.
group here, this council, we can act on recommended rule changes or clarifications, and that's it.
Yes, sir.
So if you have something that you want to change or clarify, then you need to go through the process and get it on the agenda and have that done, as opposed to doing all these other discussions. Am I?
Well, I think though, in fairness, we did ask him to put some things in writing and make a suggestion. I'm hearing one substantive recommendation from this letter and from DJ's mouth, and it has to do with warranty. But I'm just telling you, and I don't make motions because I'm the chair, but I tell you, it is my opinion that that's beyond the scope of our rulemaking. I don't think we should get into the warranty situation. I don't know that we can. as a practical matter, I don't know how a state agency is supposed to tell a consumer, "Nah, sorry, we're not going out there. Sorry, your roof fell in," you know, and maybe, you know, whatever happened, somebody got injured or, you know, whatever.
Sure.
I just don't think, you know, as a practical matter, even if we did agree with you, I think the legislature would the very next session, or maybe even in a special session, prohibit us from not allowing TDLR inspectors to go out when a manufactured home roof falls in. I don't think we can address that rule change. So somebody chime in if they want to address that specific.
And that's, you know, let me clarify. That in and of itself, if that's, you know, if that's the council decision, those are answers. That's what we're looking for. I'm not coming here saying, you know, please, you've got to agree with everything we're saying. We're trying to figure out where to go and how to operate. And there's confusion. I guess what I'm telling you is there's confusion out there, and I feel that I've probably done a poor job trying to articulate that confusion that is existing out there, which is maybe an appropriate time before I keep rambling on, that if you guys want to continue to open up the public comment, that maybe some of that confusion can be articulated to you, or maybe you just want to shut it all down. I don't.
No, and Mr. Chairman, just to, Mr. Rhonda Rubiano, to maybe define this a little bit better in terms of what Joe was mentioning earlier. The second bullet item on number 10, where it's basically asking, is there a requirement to review the report and provide correct or accurate citations to applicable code? I can see wording like that evolving into a rule or regulation where staff would, before initiating some sort of complaint, would have to offer a certified manufacturer or a certified third-party inspector or a certified design firm some basic minimum of documentation saying, this is what we find wrong, this is our basis for finding it wrong, this is the chapter and verse of the rules that we find broken, or that we find that they're not being followed, and that's it.
I think that's
And I don't know if that's in the rules and regulations right now.
And just so we can, just so that the idea, so that my marching orders are clear, because we've heard a couple of different things about bring specific cases, don't talk in hypothetical, do talk in hypothetical, go to a task force. Now it's draft specific recommendation rule changes and bring those on it. I guess I'm trying to figure out what my marching orders are.
Well, it's not to bring cases here. It's not to talk in hypothetical. DJ, I think if you can disregard everything that was said before, as people were thinking through, because basically the council's struggling because they're trying to help you and accommodate the folks that you brought here, and they want everybody to feel pretty good about what's going on or better about tomorrow. And that's why you've heard the idea of let's do a task force, and that's why you heard someone say, well, come on, bring the specifics here. I think Mr. Campos' his statement is very clear that if you guys have rule recommendations that you want the group to consider, that falls under their purview.
Sure.
That falls clearly under the purview. So the other ones of the task force and do a hypothetical and don't, disregard that. Quit going to that list, because you keep going to the list, I'm confused. Be very clear that you guys have the opportunity to work with them on rule changes and work through those issues.
Okay.
That's something that falls under their thing. Looking at cases specifically and working through the frustration that they have had with our staff. We understand that.
Sure.
I mean, we can hear, we're human, and that there's some challenges there.
Sure.
And we're going to leave this meeting, probably go right over there next door and talk to our enforcement group and say, when's the last time you talked to them? Give them a call, have them come in and sit down and see what can be worked out.
Sure.
We're going to walk out that door with that particular perspective.
Sure.
But the whole list of all the things you're confused about, man, squash that. That's slang for drop that. Just go with working with them on rule stuff.
If we can, and I would only hope that this council would never presume to give the public marching orders. But Donna, if you would, maybe as an agenda item for the upcoming meeting, to put together a very specific presentation of the rule or rules governing enforcement action against those types of individuals that fall within your authority. Builders, manufacturers, site inspectors, and have that openly presented so that we can see it, public comment can be offered, and there could be the potential to make modifications to it.
Enforcement action is not under my purview, number one, okay? Number two, if you're talking about code violations that we write up, unless this council is going to issue a interpretation of every code section out there.
I don't think, Donna, he's talking about the
Because we-
administrative process. What is the process? What is the form? What is the process? What is the appeal procedure?
We don't handle that. Enforcement handles that.
We can provide them,
Enforcement can do
we
it.
can provide them with Chapter 60 rules, which lay out the administrative procedures process. And they're going to look very much or exactly like every other state agency. Manufactured housing is going to have the same APA provisions that we have, but we will provide that to you guys, Chapter 60, because we have to follow that. And what it is, it's the human element in between that we're talking about. It's the human dynamic that folks have in regard to not having access to some of our staff, or having access to some of our staff, or not being able to talk directly to enforcement. I mean, that's what we're dealing with. And like I said, we're going to leave the meeting, and Bill and I are going to go outside that little wooden door, and we're going to say, Trevor, man, welcome aboard. You need to call everybody on this list and ask them, do they want to come in and talk? Well, we're going to do that. But it's the human piece, but we can bring the Chapter 60 rules, but they're going to look just like every other state agency's rules.
And so if I may, excuse me, please, Larry.
Mr. Chairman, Larry Wilkinson. So if I understand, if I have this correct, under number 18 here, where it says the department does the department allow subjective opinions on the basis of violations? No, the department does not. But in fact, it did happen.
But in
by the
fact,
inspector.
it's
it did
probably
happen by
somebody's
the inspector.
interpretation.
I say, how are we going to resolve that?
Can you read the rest of that?
I read all of it.
Read it all.
I think that's redundant.
Well, I know you probably did. But what we said is that we don't do subjective interpretations, subjective opinions. We have interpretations that people may differ with. And that's where it comes in. We have a different interpretation than the group has, and that's where
I'm saying the same thing.
you
You
can
are saying,
litigate things.
but if the subjective interpretation does occur, and it's not a code violation, it's subjective, how do we fix that?
Bill and I are
But
going to step
I don't-
outside that door.
I wish.
And we're going to have Trevor contact everybody on the list that has a pending complaint. And we're going to ask Trevor to talk to them. And we're going to tell those folks to go talk to Trevor and make their case with Trevor, the enforcement person.
To be fair to Trevor.
Well, not
he's
just
not
Trevor.
the attorney.
Well,
But that's exactly,
Trevor, change your name to Bill.
oh man, then I gotta,
And some of
I
these
gotta
are
do what he
still in the
says then.
investigative stage, from what I see.
but
Well-
I mean, that's how you do it. You go sit down with the prosecutors that are assigned to it now.
And if you look at the report that Trevor gave, in the first period for 2012, we had one case, and that case was dismissed, and there was no penalty, no cash. So the cases get dismissed without any penalty.
Can I ask a question about process? That's, I think
Yes.
we've kind of gotten down to that. So process, when it's turned over to enforcement, I heard Donna say, that's not her division. I even heard Della earlier say, when she brought up Donna, we need Donna because she understands the code. So if there's a violation report that states violations in code, and it's turned over to Trevor in enforcement, who doesn't, presumably, no offense, Trevor, I hope I'm not speaking out of turn, doesn't know the details of the code, like compliance, what resources is he relying on if he's going to contact someone to get to maybe some sort of alternative dispute resolution? If all he's got is the violation report, or is that not happening? Is that not part of the process? 'Cause
The process is this. You're used to other agencies that don't have resources. You're used to other agencies that have one attorney in the whole agency. They got to broker off their cases to another state agency to prosecute them. They don't have the resources. They got a general
Finance
counsel.
Commission's got some
They have a general counsel and they have an enforcement attorney who's the same person. We are functionally aligned, and you know that. When a case comes in, even when it is moved to the enforcement division, the expertise doesn't disappear. That enforcement division has full access to Donna and her staff and any other person we want to bring in to help figure out what's going on. They may look at the report and say, respondent, the person who the complaint's against, here's what our folks found. And the respondent says, oh, that's not right. Let me give you our expert's report. and they'll go through the report with Donna's group, with someone else. We have the ability to access all the resources available. It doesn't sit there in isolation.
And
And
I'm
Trevor
not-
doesn't have to figure it all
Yeah,
out.
okay, that helps, because, and I'm not here to try to throw accusations or anything
I
else like
understand.
that. I guess my job right now is, my job is to take the bullets for the industry, and my job is to kind of express some of the concerns that they have, that, and maybe lack of industry knowledge of that process happening. There feels like there's a disconnect, and I guess before someone in enforcement can recommend or come to a resolution, and before maybe they can determine that an industry or the person being prosecuted, if you will, not complying with that, requesting a SOA hearing is bullheaded, to use the term earlier. We're trying to figure out what that basis is for their determination, because we would like to avail ourselves of that process, because we think that there's a better way to do it. And one of the reasons I say this, you're right, Brian. Most of my dealings is with manufactured housing. It's with a different agency. I mean, we're talking 400 or 500 homes here versus 30, 40, 50,000 over there a year. Okay. The difference is one of the things that I see is that the level of voluntary compliance with those folks this last year was almost 40%. Now, we're talking the exact same companies. We're talking Palmar, Cavco, Clayton. So I guess what I'm saying is that there really seems to be the capacity demonstrated to get to that point, that maybe some of this frustration could be alleviated. And maybe that's a process issue. Maybe that's an education issue on our part, to tell our people, when you put your modular hat on, this is what you need to do. And so that's what I'm trying to figure out.
This is not the forum.
Yeah, and can I say, when you put your modular hat on, the codes are different also, and so you might have to meet more stringent requirements in your construction
Sure.
and what's in your installations.
Sure.
Well, I
But we
think
still
we,
build side by side.
I think we've exhausted maybe this issue
Okay.
today, and I think what we got from a couple things I heard were, Brian was telling you, don't bring us facts, situations, and scenarios that can be, adjudicated here improperly,
Sure.
that are already in an ongoing thing. But after something is resolved, if you have a specific rule change from some resolved case, that's fair. And then secondly, bring a specific rule change, and you want to use the exact specific scenario on a resolved order. That's fair if you want to use that as background. But propose us rules, like council said, 70.101
Sure.
H is not being applied properly.
Sure, and we absolutely can do that. But just so I'm clear, but the condition of proposing those rules are the basis off a final order through either a final order issued where they've either gone through
If you want to
enforcement,
use
settled, or
specific
SOA.
facts, DJ.
Okay.
If you want to just bring it in, correct me if you want to just bring in the rule change, bring it
bring
in.
it in.
But don't bring us, and then on this specific unit, this was going on, if it's still being adjudicated.
Well, and I understand, because I'm just trying to be clear if we bring forth things, because I don't want to have this kind of discussion again where you guys say, well, why did you bring this rule change? And I say, well, it's because
Yeah.
of this ongoing issue. And you say, well, we can't talk about that. So I want to know what my rules are.
Mr. Chairman, I just, I've been on the commission or council a while, and typically, if you have a rule change, then it goes through a process, and then there is a public hearing and an opportunity to bring all these things up. So there's a process in place for doing all that.
Sure.
And so that's the key, that's what we can do.
Oh,
And
okay.
that's how we can help you. So you follow the written process for bringing forth a rule clarification or rule change, then you can have a forum for a public hearing, and then, council will tell you what you can say or what cases you can bring up or not. But, our role here is to, make recommendations on any rules or rule clarification.
Can I make a comment too?
I'm
If
sorry,
it's a
no.
rule change regarding the IHB program, if it's a rule change regarding enforcement issues or whatever, that would go
To the
through
commission.
executive office and our commission, not this council.
Sure.
But you would have to take it up through them.
Roland Brown here, I'd like to comment, add a comment. It's better to think of us as the local building official that's basically statewide. us and Donna. That's where our authority is at. So when we talk about bringing something forward for the rules, it's not legal type rules, it's code basis rules. So if it were be a situation much like what we just gone through with accepting the new 2009 I codes, or if it's a an argument as far as a certain type of non-site specific type of building that doesn't work well within the code, we can address those type of things. But it's my understanding we operate more from a building official capacity, not from a legal capacity. So when it gets over to enforcement, that's beyond us.
Through the chair.
Yes.
If, on the document we have on the computer on page 146, in 16 TAC, chapter 70.63, the council's responsibilities, it's very specific as to what the council's responsibilities are. I mean, there's an A through D is all there is, and you'll see disputes, disagreements, or differences of opinion between the design review agency and the building official, code compliance, plans, reviews. It's real specific, and I think most of what we talked about in this section has not been part of that responsibility at all. It doesn't appear to me, because it's very specific. It's like a half a page, and it's pretty much on point as to what this council's responsibilities are as far as compliance disputes go.
Okay. I think a lot of this that you sent us, I sympathize with as a stick-built home builder, and they have mostly to do with warranty, but I just don't think you're ever gonna get a governmental body to not respond to a member of the general public that calls. I mean, you know, it's just an exercise we all have to go through as people in the industry that's dealing with the general public. I mean, there's going to be some unfounded complaints that get filed, and we're just all going to have to work through those. Hopefully, you'll have some receptive inspectors that recognize too that this is kind of an unfounded complaint. But if not, that there's still the due process.
Just to ask quickly, Mr. Chairman, you know, you sound reluctant about that being the status, and maybe it absolutely is, and you've got personal experience with that. In an ideal world, from your opinion, would it be better if that changed?
Well, of course, and we had a TRCC for a while, but that was an individual statute. It wasn't something we came before.
And that's what I'm talking about.
You know, I mean, but we went to the legislature as home builders and said, give us a state warranty, a state home building warranty with specific tolerances and specific, you know, technical variances and control measures.
Sure.
And if something's, you know, a half inch off level, it's deemed level, of course. But I mean, they took our state agency away at the legislature too.
Well,
we thought it was a great idea for both the industry and consumers.
Sure.
And so maybe that's an outlet.
Maybe that's what I'm trying to figure out is what, I mean, because I'll go back and tell my folks, well, this exactly reiterate what y'all said is that, you know, these are the limitations with which the council has. This is what they told us we could, you know, the structure as far as proposing process and administrative changes to go through that process if we want to try to do that. But some of these might have to be resolved elsewhere, whether it be civil court, whether it be legislative advocacy, whatever.
I don't think this body, and somebody correct me if I'm wrong, has any purview over performance standards or tolerances or warranty specifics. And I don't think, even if we had unanimous consent here that we all want to do that, I don't think we can. I don't think we can.
So by that, nor does the IHB division?
The performance standards, the code does address performance standards, and the council can approve alternate materials and methods of constructions. That's what their limits are.
When
on
I say
that.
performance standards, though, Donna, I'm speaking in terms of warranty. I'm
No, we
I'm
don't-
talking of
yeah,
performance
okay.
over time.
Okay.
I'm not talking of the material requirements for
Okay.
construction. That to me is not a performance standard. A performance standard is I built it and it maintained soundness and levelness over.
To a person who deals with building codes, what you're talking about is not a performance standard. So,
Mr. Chairman, Rhonda Rubion, I think I'm understanding the frustration, and again, I would suggest that the people that you represent go back to the rules that this council has authority over. And I recognize at the moment I say enforcement, we want to pass the buck, but there's got to be a moment somewhere in those rules, or you can propose a rule that when a complaint comes in, assuming it comes into the IHB program and IHB staff,
No, and they never come into us, they go into enforcement directly.
no problem. No, but again, to offer some relief should, and that's what I was real curious about. If you think IHB staff, through their actions, are creating some of your frustrations, then propose a rule. Propose a rule that says, when you take this action, this is the minimum burden of proof you should have. Things of that nature. I don't see why we cannot do that as a rule. But if it goes to a completely different agency, a completely different side of the commission, we're your wrong audience.
Sure. Okay.
And I don't mean to cut off, is there any other public comment? I mean, I don't think there's gonna be any relief from this body today with what's before us, but I do want to allow people that have traveled here to address
Me too.
this committee and invite you to come and make public comment, if you've signed up to make that public comment.
Thank y'all.
So, thank you, DJ. Yes, sir. Come on forward.
Thank you very much. I'll try to make this very brief because kind of outlined a little differently what I was going to talk about. My name is Wesley Hayes, Advantage Housing Corporation. I've been in this manufactured modular home business for 39 years. Been an owner-operator for 26 years of Advantage Housing, and have sold over 1,800 and installed 1,800 manufactured and modular homes. My issue is more procedure, and I understand that you guys won't have anything to do with that. That would be these guys. But this is my opportunity to speak, and I drove 250 miles, so I'm going to do it. I do most of all my building now in Galveston and Bolivar. They're elevated, and we use our engineers, your engineers. This is who we do. From the first nail to the last nail, they do the inspections, they do the finals. When we have a complaint, which we have had, it seems like the engineer is left out of the mix. They don't. We had a inspection that we were not invited to. Happened in June, of which the complaint was in March. Happened in June, we weren't invited to it, and neither was the engineer. And it would seem to me that because it's such engineer-driven, that they should be there for the code compliance. Also, the report of findings was issued without any input from my company, me, or what possibly happened. And when that does occur, in the findings, it shows some things that occurred, the violations that occurred, and then it says responsibility of the industrialized builder. Well, this is an open record. Customer attorney can get this. And I'm a small individual, been in business a long time, like I said, but I got to spend attorney money defending something that this is public record. Without the benefit of my input, this is produced. The production for me was 2 months later, when a different person, the investigator, came and asked me what happened, what's the deal. Well, the customer modified the home. I didn't have a thing to do with it. They modified it after inspection. But in any event, I think some of the procedures that need to be, I would suggest changing to is before these reports are written and sent, please involve the builder, especially the engineer, because this is what we go by. He's responsible for these. If the code's wrong, then he either did it wrong or the customer did something. But we are there to help these customers. It's been 8 months since anything has been determined. Nothing yet has been determined. And I've got a customer out there who's very unhappy, and I want to make him happy. Let's get this done quicker.
This is very good comment, sir. I appreciate you telling us that. If you could just sit there for a second.
Yes, sir.
I don't know that we have any purview over the administrative procedures as to how this works, but I would agree with you that you as the builder, manufacturer, and your engineer, if you can get him, but at the very least you as the licensed, certified individual, can we not invite those people to those inspections? Because that was one of the things we had very clear for single-family home builders is the home builder was always given the opportunity to be there for the inspection when the state inspector came out.
Well, number one, I appreciate you making the trip and coming up here.
Yes, sir.
And these are really constructive comments. It's not anything new that we haven't heard. Some of the scenarios is that, maybe the homeowner doesn't want the person back on their property. We can't force a homeowner to allow somebody out there when we do an inspection. That could be a scenario that comes into play. So those are things that we have to factor in. It's not something that we can force into their home to do the
But Brian, you can make that as a condition to them inviting you on.
Why would we do that? Why would we remove ourselves from the opportunity to perform an inspection from a complaint that was filed by a consumer? Because the consumer says, I don't want the person who I'm complaining against to come out here with you.
Well,
The
I
question, Mr. Chairman?
can give you an answer, but I don't want to. Because it's a very subjective thing we're all doing. I mean,
I agree.
In a home, at the Texas Association of Home Builders, when we were testifying, there's 10,000 components that go into the building of a home, and so out of those 10,000 different components, of course, there's a subjective nature to one thing or another, and to look at a bent nail, just to make an absurd example, and to determine whether it's bent or not, I think it doesn't harm to have 3 people there. I just don't see the harm in telling the consumer, look, I know you don't like this guy, and you don't have to talk to him, but procedurally, we want to set a mechanism that's fair, and just explain to the consumer, so he can't challenge the validity of what we're doing later. It's making it more valid by having the constructor, whether it's a manufacturer or builder, there present. It just prevents this story from being told.
The builder does not lose the opportunity to defend himself. That's an inspection.
What I'd
I'm
like
going
to
to
say,
finish the
though.
thought real quick.
Yes,
They do
yes,
not lose
he
the
does.
opportunity to
But wait.
defend themselves. That's an inspection report. It's not the investigation report. That's the inspection report. It's a component. And as the gentleman said, an investigator contacted him and said, what's your side of it? That is always going to be available. They have that opportunity to tell us every time. It's just one point in time that if the homeowner chooses not to let the person out there and we don't have our folks refereeing some conflict that's been ongoing for however long, that's how we do it.
Okay.
Well, my problem is the investigative report, not but the findings assign responsibility before I get a chance to give information. That should not happen. Let's get all of my information and then write the report, because yes, the investigator contacted me 3 months after this report was issued. I didn't even have the benefit of having this report until after 3 months. And here a customer sits seething. They're upset.
I agree with that.
And I want to take care of it one way or the other. So the only thing I'm suggesting is, and this happens, I understand, is before you do your findings, please get our side. and then do it. And don't put responsibility where an attorney can get a hold of this, and I gotta spend $10,000 or $20,000 of money defending myself. That's not fair.
Mr. Kuntz, what is the proper venue for him to have his concerns with the administrative process as far as a field inspection to be heard? What would be the proper body for him to
Come talk to the executive office. We can take a look at saying it's preferred if the builder goes out at the time of an inspection when we have that disagreement, but that's going to be up to the homeowner to find out whether they want that builder back on their property. Because more often than not, when somebody has gotten to the point of frustration where the builder has not responded to their issues, and they call up and say, we've got a problem, we want to report a violation, they don't want to have that person back out there. And there have been some nasty situations where people have gotten into major shouting matches, and we don't like to be caught in the middle of that. Also, just for an example of what happens on the time, this quote warranty issue, the 2 years. I've turned away many complaints where the complainant has come back and said, you've got to open this up. I know it's more than 2 years, but you've got to open this up. And we say, no, we can't. We won't. And there's been so much time that has passed, we don't know what the original built condition was, what the changes were along the way. And it's, those get turned away.
That's good.
Mr. Chair.
Yes.
Mr. Kuntz, if I could, and I understand and don't really want to get into the timing of the inspections, having both there, but furthering our chairman's request for a proper venue, I would have more of a question as to why or how is a document as such that is being presented right now produced without the input of all parties involved. I don't want to, again, my question is, assuming that is a fact, what is the venue for him to share that frustration that in fact a state document claiming responsibility was authored and issued of record without all parties having an opportunity to input into that document? I don't want to discuss whether it happened.
Let me go
I want
to
to
a different
discuss.
program to explain it.
Yeah, if I-
Architectural barriers program. A plan is sent in, it's reviewed, and they say, yes, everything's okay on this, or they say, no, you've got to make these changes. And then after the construction, inspection is conducted. You say, oh, they didn't build it according to the plans. These are the problems that we see. That the architect is not invited along to do that. The inspector goes out and inspects the property. That inspection report then is the inspection report, and then it's sent back and say, okay, we need to make these corrections. So,
I don't disagree, and please, again, I'm not here to argue it. I haven't even seen the document this gentleman has. An inspection report is one thing. A finding of responsibility, in other words, and I'm familiar with
right,
what
and
you're saying.
I think that we can look at that and say, all right, our inspectors don't need to make that statement.
Correct.
That's
The
something that we can
TDLR
look
inspector,
at, yes.
in your example,
go a long way, I
the
think.
TDLR inspector can clearly say, this does not meet the code, and stop there. And say it needs to be resolved. Who resolves it, whose responsibility to resolve it, whatever is subject to the next step. But it sounds like he needs a venue to discuss why a document was produced asserting responsibility without all parties being discussed. And I don't want to see the document, I don't know the document, I'm asking what is the venue for him to express that frustration?
You know, I think Joe Campos, I think the analogy was, you know, like, this is like a code authority. And you wouldn't have a code official rendering an opinion as to who was responsible. They will go out there, if they were even involved, would just say, hey, this is what we observed. And I think that's your point.
That's exactly my point.
And so maybe that is something that you all need to take a good hard look at, because I think that might be somebody overstepping, if in fact they're rendering an opinion.
What I'm hearing is that a change in procedure would probably be able to take care of that.
And I think that's wrong.
Mr. Chairman, and doing so without all the facts.
Well, even if you have the facts.
Well,
you
but
have
without the facts, how can you publish that rendering? How can
No,
you
I guess
publish
what
that
I'm
statement?
saying, the person should go out there and say, this is what I have observed, and not render an opinion as to who's responsible. That's a whole different venue. And anybody, to me, that's of course, I haven't seen the document, as Rhonda said, I haven't seen anything, but if that's happening, that, that's not the responsibility of inspection.
And just from a builder's perspective, Mr. Kuntz, the Architectural Barriers Committee that's typically inspecting for handicap accessibility and things like that, that's a much more prescriptive, objective code than there's a wave in this wall. Because the UFAS codes and things are like 36-inch opening here, and it's 17-inch the toilet from the wall, and they're very prescriptive. That I think what at least me as a home builder, I sometimes struggle with an inspector is he thinks, that bow in the wall is unacceptable, and, somebody else might think that's an acceptable tolerance. So I just think there's a highly subjective thing, and I'd like the builder to be there. I'd like to see staff at least recommend to the consumer. It really would help if we had the builder there, if you're really interested in a resolution.
But then you're trying to put the inspector in the position of making a judgment as to who's responsible, and that's not their job.
Yeah.
The roof falls in, you go out and you say, yes, the roof fell in, and I observed these code violations or these structural failures, and that's it. You don't sit there and say, well, that was the builder did this wrong. I mean, you just.
Well, I totally agree with you on that.
That's really, I think, maybe the issue, and if that one issue could be addressed and changed, then a lot of this goes away, because then you have a document that just documents what was observed by the inspector, and then you can have your engineer render a different opinion, and then let the legal process and the appeals process take its course.
That would be,
I'll take a look at this. We can bring back to you what I find, and also we can give you a complete explanation of the enforcement process.
That'd be
Which
great.
starts with a complaint, inspection, referral to enforcement, the way that the enforcement goes through with it, because this instant case is still in the investigative stage. It's not even gotten to a prosecutor.
Okay.
But again, is that the responsibility? Can this board do anything about any of that?
No.
But I think you guys have just helped right
What you've done
there.
is you've raised the issue. We know that there's something that we want to take a look at, and we will take a look at it.
Thank you. Thank you.
Good. Thank you, sir. Is there anybody else that would like to address? Mr. Montgomery? Yes.
Brief comment. I don't have to have a response. I just want to make a comment because I feel like some of the context of what may be perceived, the roof falling in has been used over and over again. That's, at least in my mind, what has kind of been seen as not the issue. That's really not the resolvability issue. A more, a better example might be the carpet's loose after 3 years. It's cited as a code violation. Or you might have a window that is sticking after several years. Well, the code violation states that the windows have to be operable in the bedroom. Well, we all know that, but it was operable for a period of time. So I guess the point being this transition between initial construction, it's built to code, we all agree with that, then what happens 2 years after the road where it becomes more of a performance of how they maintained it, how the window operates, all the conditions that are affected around it. So again, I want to put more in context at least my issue is.
No, I think we understood that,
magnitude.
Mr.
It's
Montgomery.
the little
And
stuff.
the reason I used that example is because what I understood the ask was from your group was a policy change to whereby after 2 years, staff doesn't send anybody out. If Mrs. Jones calls on the 800th day after, more than 2 years,
Right.
that we just don't go out to see if it was a roof or a carpet, or we just tell them no.
Right.
And I don't think we can
Yeah,
expect the state.
Right, and I don't
agency-
disagree with that. The question being more from the side of where do you transition between warranty, is it okay for a report to be written by the department and assign responsibility on an item that is, everybody agrees is aesthetic in nature, and give the authority of the state behind it?
And is not a code violation.
It's not a code violation. it's, you know, it
You
is
don't have the
what it
right
is.
to make the comment. It's not a code violation.
So, I mean, you can stretch the code and twist the code and try to apply things and design ought to do blah, 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 and you don't really try to, but the fact is, it's 3 years later, you know, window operability, yeah, the window was operable for the first year for sure, you know, that kind of, so, that's all I have.
Mr. Chairman,
Yes.
I'm going to exercise what my mom taught me.
I've got a note from Tamla because she has to do the minutes. The public commenters need to give her their forms before they leave.
Yes.
'Cause we've
Please,
not
if you
been
guys
collecting
wouldn't
those yet.
mind just bringing those to her, you know, now would be great. I mean, just, you know, it's not such an intrusive. And is there any more public comment, ma'am? Yes. And also, if you could state your name for the record.
Good afternoon. My name is Rhonda McAllen. I'm the State Compliance Officer for American Homestar Corporation and the Oak Creek Homes Division. Basically, I just want to support what Mr. Hayes and Mr. Montgomery has already said concerning the inspection and the ability for the either the builder or the manufacturer and the engineer to be there. The one thing I would like to ask staff is that I have an open case where an inspection was done in 2009. I didn't receive the inspection report until 2 years later. I've sent it back to enforcement asking that a new inspection be completed. I think it's the timeliness of the builder and the manufacturer receiving the reports, the inspection reports, is critical. The other issue that I'm having, and I think it's some of the same issues that Mr. Hayes was having on the inspections by not having the engineer and the builder there, we are what appears to be, we're getting a lot of, what seems to be a lot of inspection reports which have subjective opinions and not code-based opinions. And I just have one illustration that I would like to show the council that I think will make my point. I have a case where 8 of the violations in the report, which were deemed to be the responsibility of the builder, those violations were based solely upon a tire being blown while the home was being transported. And the evidence that the inspector gave us for the blown tire was a photo that the homeowner gave the inspector of a broken toilet lid. Now, the toilet's not broken, the walls aren't damaged, the floor's not damaged, the tank's not damaged, only the lid is broken. And I believe, I don't know whose writing this is, but it says, picture from homeowner showing damage to bathroom above wheel that had blown. I think anyone knows you can knock a toilet tank lid off fairly easily, especially when one is going down a road. So it's my feeling that I would like the department to take a look at the reports on the open cases, and especially those that contend that violations were committed based upon this type of evidence. But I do feel strongly that the manufacturer and the builder and the engineer need to be notified that these inspections are occurring, and it's critical that those inspection reports get to the proper parties in a timely manner, in time for us to take care of the homeowner and the issues and the violations that they find. Thank you.
Mr. Chairman, I'm going to break my mom's rule.
Yes, sir.
Don't tell her. Number one, sounds like she raised some great defenses that she can use. Number two, our inspectors have integrity and they're competent. They don't get it right, just like the owners and builders don't get it right every time. But there have been too many comments implying that they're purposely or they're not doing their job well. Subjectivity is built into the process. It's interpretation. You get to offer that as a defense. In the information that we responded to, we agreed. Like I think on question number 3055, I think we said that we agree that the reports, when they're completed, should be given to the builder in 30 days. We agree with that. And we failed that, and we're going to fix that. So I wanted to say we do agree that they should be getting there timely. I do want to say that you have opportunity to build these wonderful defenses about toilet tops and that sort of thing into it. But I just want to stand firmly in defense of our inspectors because they do a hard job and they have a tough job. They're out there protecting the consumer. You guys are out there serving the consumer. Sometimes those things are divergent paths, or it seems. But at the end of the day, he does his job fairly and he does it well. Well, I'm not saying you guys aren't against the consumer.
What did you just say?
Well, I probably said something stupid then. I didn't mean to. Let me say it this way, is that sometimes our jobs are going to be a little different. At the end of the day, we just got to talk to each other and keep talking straight up and do it well. So if I offended
I
you,
didn't say anything about your inspectors, I'm just talking about the procedure.
I wasn't talking about you then.
Well, you said, okay,
There you go.
but I still.
All right.
If the shoe doesn't fit, don't try to wear it. Cramp your feet.
That's exactly right. And he goes,
There it is.
Keith Alexander, manufacturing member of the TMHA board and manufacturing GM for Palm Harbor Homes. Just one question of the board itself. I think as it relates to our whole industry and to all of our builders and manufacturers, is the board a consumer advocate for the consumer or the independent third party for the state of Texas, trying to find out if there's actually code violations that has happened on a bill? Is your responsibility to be a consumer advocate or to be an independent third party looking for code violations?
The agency is responsible for enforcing the codes, doing compliance inspections. We're also responsible for providing consumer implementation for protection of the consumer. So the roles can vary. But yeah, we're there to enforce the code. I think your alarm.
It is.
So yeah, it's not one
So
or the
is
other.
the industry a customer as well as the end consumer?
Yes, it is.
Absolutely.
Now,
So
and
I think what you're hearing from all of us is we would like to see some procedures and rules so that it is truly available to both sides of a dispute as you go out and do inspections, that's truly an independent inspection and not fodder for later legal cases when we can get it resolved for the consumer up front and quickly. That's what we're all after.
I think that's a great question. I will tell you that unless my boss pulls me back, I will not promise you that when we go out and do an inspection, if the homeowner says you can't come out there, that we're going to bring you out there. I will not make that promise. But we can promise this, is that before we go do an inspection, we will ask the homeowner if he wants the building, if he wants to allow the builder there, and we will let you know when we did the inspection. We can do that.
That's great.
Thank you.
That's great.
Okay, anybody else? Thank you all very much for your public testimony, and thank you very much, Brian and Mr.